hearing subcommittee today. The meeting will be chaired by Councillor Brenda Massey, who I will hand over to now to make the introductions and to coordinate proceedings from this point. Thank you.
Thank you, Claudette. Good morning, everybody. Thank you for coming today. Can I start by asking members to introduce themselves? So for myself, my name is Councillor Brenda Massey and I represent Southleigh Ward. So can I ask my fellow councillors to introduce themselves, please?
My name's Lucy Whittle. I'm councillor for Windmill Hill.
Tom Brooke, councillor for Bishopston and Ashley Down.
Thank you. And excuse me from looking away, but I'm trying to balance an iPad and a laptop, and it means I can't look at everybody all at the same time. So apologies if it looks as if I'm looking away from you. I'm actually reading what I've got in front of me on screen. It's one of the issues about doing virtual meetings, as I'm sure you're getting very accustomed to doing. So as far as housekeeping rules go, obviously we would normally go through things like fire drill, but I'm assuming you all know how to get out of your own houses or offices, wherever you are, so I'm not going to go through that one. I hope everybody can hear us all right? Yeah, good, that's fine. So you will all be on mute until it's actually an opportunity for you to speak. And at that point, each member will need to unmute themselves. So the procedure basically is that this is an informal, non-adversarial meeting, and all comments should come through me, please. And can I now ask the licensing officer to introduce the report?
Thank you, Chair. So as you're aware, this is an application to vary the licence of Taka Taka at 5 Broad Quay in the city centre. The current licence authorises opening hours and late night refreshment until midnight every day. This application seeks to extend the terminal hour until 4 in the morning on every day of the week. As you know, we did receive representations in relation to the application, 3 from relevant persons, 1 from the police and 1 from the licensing authority. The applicant has now reached agreement with the police. The agreement is that the application will remain for late night refreshment to 0400 every day, but the later part of the application will be for home deliveries to registered offices or a registered address for home delivery. Public access to the premises will be restricted Sunday through to Thursday to 0100 hours, Friday, Saturday, New Year's Eve and Sundays before a bank holiday to 0200 hours. And that's all been agreed with the applicant and the police. They also agreed a number of conditions in relation to door staff. You've had those through in your paperwork. The door staff condition says that the license holder will undertake risk assessments to determine whether it's appropriate to employ door supervisors on any day that the premises is open to the public. Unless otherwise agreed with the police, a minimum of 1 door supervisor will be deployed from midnight until close on any Friday, Saturday and Sunday that falls on the bank holiday weekend and New Year's Eve as well. There's also some other general door staff conditions, and access to the premises by members of the public will be restricted in line with those hours where home delivery commences and public access closes. Thank you.
Sorry, I was just trying to find the unmute button, which moves around according to which item of IT you're using, so apologies for that. Right, members, do you have any questions for the licensing advisor? No? Okay. In that case, I will ask the applicant to present the case.
Thank you very much, Chair. I'll do that on behalf of Mr. Miaris, who is effectively the applicant. He's the owner of the company. Just one very small but late change. I've been having discussions with Mr. Lyle earlier on this morning with regard to the door staff conditions. And subject to one amendment, and he can of course speak for himself to confirm this, he is content with the wording that you've just heard in terms of the risk assessment and agreements with the police, etc. However, what he has asked for is a very small amendment so that the second sentence of that condition, instead of reading unless otherwise agreed with the police, a minimum of one door supervisor, he has asked, and we are perfectly content to amend that so that it reads unless otherwise agreed with the police and the licensing authority, so that both the police and the licensing authority, of course they work together, but they also work independently, and they both know what's going on at any given time. And the last bit of that condition asserts a copy of the current risk assessment should be kept at the premises and a copy provided to the police and licensing authority on request. That was already there, and therefore we have no difficulty with that. Subject to that, we therefore have successfully mediated with both the police and the licensing authority, and therefore that only leaves the representations that have been made by those that I believe Mr. Woodcraft, whom I see here today, represents. I can really do little more than to point you in the direction of the Regulatory Service Manager's report, which very accurately sets out the background and the very material change in circumstance that has come about since we made the application for the what is now the license much earlier in this year, when the application was granted, but as you know, limited until midnight. The effect of this variation would be relatively minor in that it would allow the premises to remain open to the public until 1 a.m. On most days, and 2 a.m. Fridays, Saturdays, and then bank holidays, Sundays, and New Year's Eve. Of course, as of today, to an extent, and probably for the next 6 months at least, that's all rather academic, because the premises will have to close to the public at 10 p.m. Along with everybody else. It is also the case that for the last several weeks now, at weekends, a series of temporary event notices were given that have allowed the premises to operate as we now propose, following this agreement with the police. In fact, the temporary event notices were rather more generous than that, but the premises haven't actually been open at 2 o'clock in the morning for passers-by, for the very simple reason that, to all intents and purposes, there haven't been any. You may recall, and I think, Madam Chair, you actually chaired the meeting, that the first of the ordinary temporary event notices was objected to by the police. We had a hearing with regard to that, and the objection was overruled, and the 10 was allowed to go ahead, and all of the subsequent 10s that were given did not then raise an objection. The timing is perhaps a little significant because we have now run out of temporary event notices. We cannot give any more because we've used up the full quota of the 21 days in any calendar year. If I may then, I don't think, unless you would like me to do so, I don't think that it would serve any useful purpose to go through the representations that were made by the police and by Mr. Lyle, because those have been successfully mediated. But if you have any questions, then of course we would answer them. And may I therefore turn briefly to the representations that have been made by 3 persons who in fact all operate competing businesses in the locality of Broad Quay. But basically most of them are on the other side of the road, but one of them to the right of the existing premises, the food bar. These representations are something of a rehash of representations that were made with regard to the original application, and have been overtaken by history to a very large extent. The representations also fail to take into account the very significant change in your policy that is referred to accurately in the service manager's report, because it relies very much on cumulative impact. And of course, as we stand here today, whereas there is a consultation going on with regard to cumulative impact assessment, we're only not even, I think, halfway through that, because I think that started on the 2nd of September and is due to end on the 28th of October. It would be entirely wrong to base your decision on an assumption that the cumulative impact assessment will survive, as it were, in terms of public consultation. And it would also be wrong to assume that even if a cumulative impact assessment is forthcoming, that there would then be a subsequent change to the policy. As a matter of law, you have to determine the application as it stands today. And there is no evidence adduced by the three private objectors, if I may call them that, of any cumulative impact that the grant of this application would result in. I, of course, appreciate that we live in very strange times at the moment, and that what has happened over the last couple of months, whilst the premises have been operating at weekends under temporary event notice, is hardly typical of what has happened in the past. Of course, part of the problem is that none of us have any idea at all what is going to happen into the future. If we knew that, I think we could all become very rich people by gambling on the stock exchange appropriately and the like. But that's not the situation. I'd invite you to take the view that you take your lead on all of these matters, be it crime and disorder, be it public nuisance, protecting children, etc. You take your lead from officers. Your own officer, Mr. Lyle, and the police are perfectly content with the application as amended. And against that background, I would invite you to grant the application. I would only add one other thing, and it is referred to in the manager's report. It is our assertion, most definitely, that the offering that Taka Taka provides is radically different from those of the other takeaway establishments around Broad Quay and in the area. It is Greek cuisine. There has been a huge demand for it, increasingly during the lockdown period. They use various delivery services, such as Uber and Deliveroo and so on. And the Taka Taka brand in Bristol has been rated as the #1 brand by some of those delivery companies. It has been very busy in terms of deliveries. It hasn't caused any problem. There was some concern expressed about, well, how can you carry on doing deliveries and having these bikes and cars and vans or whatever they are coming up to the premises and remain closed to the public? Well, the reality of it is that that hasn't been an issue, and it never has been an issue. The lights are still on, regardless of anything else, for at least half an hour after the premises closed to the public, whenever that closure is, because staff are obviously in there cleaning up and everything else. There's a sign in the door saying that they're closed. The door is shut and locked unless they have to allow in or out a delivery driver or motorcyclist or even cyclist, and it hasn't caused a problem. If in the long-term future it does cause a problem, then, as we all know, this license, in common with any other license, can be the subject of a review, which could ultimately result in a revocation, no action, and all things in between. So, Ma'am, those are my submissions. Unless I or Mr. Miaris can assist you in answering any questions that you may have, I would invite you to grant the application as amended during the mediation process with the police and then with Mr. Lyle. Thank you very much, ma'am.
Thank you, Mr. Day. Members, do you have any questions? No questions? Right, okay. Officers, any questions from you? No? All right. In that case, Mr. Lyle, do you have anything to say? Any questions? And then I'll come to Mr. Woodcraft.
Thank you, Chair. Yes, I've carefully read this application for the variation of a premises licence with the Bristol City Council licensing policy and licence objectives fully in mind. My fears, which I reflected in my report, have been allayed after my discussions with Mr. Day, and I am happy that the premises are adequate, will be adequately conditioned in support of the licensing objectives, and obviously the police have agreed as well with these conditions, and I fully support them.
Thank you. Mr. Woodcraft, do you want to say, make a submission? Could you unmute yourself? Thank you. That's it.
Good morning. I'm here today speaking on behalf of the three private persons, as they've been described, who've made a representation. I say quite openly at the outset, it is quite correct that all three of them run late night refreshment premises in the close proximity, but that in itself does not preclude them making representation, or indeed preclude the committee considering the same, provided, of course, what is said is relevant to one or more of the licensing objectives. I will, in the first instance, pick up on the point that Mr. Day has made, that obviously the fundamental difference this time round to the previous application when the license was granted is that the cumulative impact policy is no more. However, that said, the council policy, you will be aware, does still say that you can consider the cumulative impact of a number of similar premises in any given area. And I think it is probably a fact that if this application is granted, it will add to an area that is already amply served by any number of late night refreshment venues. Certainly, as I say, I'm here today speaking on behalf of the owners of 5, and I believe there are certainly more than that. You will have heard on many occasions from the police the suggestion that the greater the offering, the more the people are attracted, and the more adverse impact that can have on the crime prevention and nuisance objectives. So I would also agree with Mr. Day that really it is a matter for effectively a reversal of the burden of proof. Last time round, when there was a policy in place, it would have been for the applicant to produce evidence that the granting of the application would not undermine the crime prevention objective. This time round, it is really for evidence to be produced to say that it would. So the question arises, where would I ask the committee to look to identify evidence that this application could have an adverse impact on the crime prevention objective? Well, the first point, Mr. Day makes the point that agreement has been reached with both the licensing enforcement officer, Mr. Lyle, and the police. Now, the fact that they made representation suggests that there must be some issue with crime and disorder stroke nuisance in this vicinity. The fact that there is a compromise does not get away from that fact. There must have been some concerns to start with, and of course a compromise is always just that. It is a compromise where both sides perhaps don't get the full extent of what they were looking at. So that is one thing that you can certainly take into account in terms of evidence. The other factor, again, is the assessment that is going on at the moment. Now, you will be aware that Bristol City Council had any number of cumulative impact areas, and I think it is correct to say, the committee will be probably very alive to this, that in terms of all of those areas, the only one where it is thought that there is still adequate and sufficient evidence to reimpose a cumulative impact area is in the city centre, albeit on a slightly reduced geographical area, but still very much relevant to this area. So out of all of the cumulative impact areas that there were, this is the only one where there is still, it would seem, sufficient evidence. And whilst, as Mr. Day says, we can't prejudge the issue, again, this is another area where you can look to say, well, yes, there must be some evidence there that there is a crime and disorder issue. One thing that I haven't seen, as it was not part of the papers sent, is the operating schedule that was submitted with the variation application. So I would just invite the committee to have a look at that operating schedule, because the guidance says that obviously that is where the applicant must describe the steps they will take to promote the licensing objectives. So I would ask the committee perhaps to look at that. I haven't seen that. Are those steps sufficient, given that there clearly has been some concern in relation to crime and disorder and quite possibly nuisance? I think Mr. Day very fairly described the use of the temporary event notices. They're probably not overly indicative in the current environment of anything that may happen, hopefully in 6 months, a year's time, when things get back to normal. So I won't make any further point on that one. The one thing that I would ask the committee to factor into their decision-making process is that this is a decision that is of some interest to any number of late-night operators. You will have heard of the floodgates argument on many occasions, but this, I believe, is the first application that comes before you since the removal of the cumulative impact policy in the city centre. And of course, there are any number of businesses looking for extensions, new licenses, and with the likely change to the business dynamic in the city centre, any number of premises that may be looking for any other kind of outlet for premises that previously were possibly used for other things. So it may be very much that this is an application that may facilitate or encourage any number of other applications. And obviously the committee will be very aware of the extremely long time that the council and the police took enforcing the policy to secure, shall we say, a reining back of the late night economy that had gone somewhat out of control. And obviously, whilst it may be some weeks or possibly even months before any policy decision is made, clearly that good work could come under scrutiny and under threat. As I say, this application is going to be one that is going to be of great interest to a number of other operators. If you are looking for further evidence of crime and disorder, well, I would identify the door staff condition. And also one thing that I would ask you to consider, and I'm sure your licensing officer can probably assist on this point, is that the door staff condition on 4 out of 5 of the premises that I represent is more onerous than has been agreed in this instance. And obviously a fair playing field would be something that we would ask you to consider if you are minded to grant this application. The fundamental additions, if you like, to the door staff condition currently agreed are an extra day of the week. Our premises, or 4 of our 5 premises, are obligated to have a door supervisor on Thursday for anything after midnight, and our door staff start at 11 p.m, not midnight, but that is perhaps just a small point that I would ask you to take into account. My final representation for the committee to consider is this. I'm not sure if any of the committee actually sat on the original grant, and I'm sure the applicant's representative will say this is old news and old hat and has been dealt with. But it was established that the applicant had traded this premises for a number of occasions without a premises license. And obviously, when you're looking at the crime and disorder objective, it has to be questioned whether an applicant who is willing to do that will or can be trusted to uphold the licensing objectives if such an extension is granted. So those are the factors. I would ask you to say that there is evidence from various sources that there is an issue surrounding crime and disorder in this area, and undoubtedly, as you will know from previous experience and your own experience, that this would add to that and potentially undermine the crime and disorder objective. Thank you.
Thank you for that. Members, do you have any questions? No. Any officers have any questions? No. In that case, can I move to Mr. Day for the summing up?
Thank you for that. If I can assist Mr. Woodcraft, the application, when he talks about the operating schedule, I'm assuming that he's referring to section M. For his benefit, what section M actually says was note for information purposes only. The license is already subject to a comprehensive set of appropriate conditions. Having reviewed the position, the applicant does not consider it appropriate or necessary to offer any additional or amended conditions. But that, of course, is now subject to the agreement. Well, sorry, not agreement, the mediation with the police and with the licensing authority officers themselves. Secondly, Mr. Woodcraft says that this is of interest to any number of late night operators. This was a question that arose. Mr. Woodcraft obviously wasn't there when the temporary event notice, the first of those, was considered. And I will explain to this committee what I explained then. We were aware back in January, when we originally applied for this license, that the current statement of licensing policy was due to expire. And we watched the situation with some interest as the new policy was in the process of being adopted. The timing of this application was entirely deliberate, as were the giving of the temporary event notices, to coincide with the adoption of the new policy. The new policy came into effect on the 1st of August, and this application was made 2 days later on the 3rd of August. With that in mind, yes, it is arguable that people would view the decision that you make today as a precedent. However, it is crystal clear that the guidance, the policy that you have, both old and new, makes it very, very clear that each application has to be considered on its own particular merits. You can't point to somewhere else and say, well, you gave him, her, it, that, whatever it is, therefore you must do the same as far as I'm concerned. Situations change, and each application is unique and has to be considered on its own merits. Next point, and it's the penultimate point, Mr. Woodcraft talks about door staff conditions that his clients have to contend with are more onerous. Well, each case has to be determined on its own merits and in the particular circumstances right now. And I'm sure that given the current circumstances, it may now be a bit academic with everybody having to close at 10 o'clock, but before then, it would have been perfectly open to any of Mr. Woodcraft's clients to seek, in effect, relief from the conditions and to go back to the licensing authority with a variation application to say, well, look, what is the point of having door staff when there's nobody here? Can we not amend the condition so that it reads the same as the condition that we've agreed with the police and the licensing authority? The final point that he makes, I'm not going to deign to deal with. It was fully canvassed months ago, back in January. You decided to grant a license now. At that point, it is totally and utterly irrelevant to the variation application that you have to consider today. And I therefore again invite you please to grant the application, subject of course to the mediation with the police and with Mr. Lyle. That's all that I would say, unless I can assist you or your colleagues or anybody else any further.
Thank you for that. I think we're ready to go into private session now. Claudette, can you outline the procedure for everybody, please?
Thank you, Chair. So we will put the applicant and the relevant persons and their agents back in the waiting room, and my colleague will let you know when the decision has been made. Thank you. And members, you'll be asked to join the breakout room. Can you click and select? And the legal and licensing officer, please, if you can. Thank you.
Hi, Carl. Sorry to admit you. Claudette would like to have you in the breakout room. So I'm just going to leave you here a moment and then she will bring you into the breakout.
Just one moment, please. Chair, I'm just going to send a message to the waiting room and let them know that I'm going to invite them in. Chair, I'm just invited the parties back into the room, and I'm okay. Are we all present? Chair, we're all present, so if you'd like to go ahead, thank you.
Good, thank you. Thank you all for coming back again, and I will now read out our findings. Members have carefully considered the representations made on behalf of the applicant and the relevant persons, and had regard to the conditions agreed with both the police and licensing. They considered that there was no impact zone currently in place in the relevant area, and were satisfied that the conditions agreed and the reduction of hours would enable the applicant to meet the licensing objectives. The license is therefore granted in part and refused in part. Thank you.
Thank you very much. Thank you. I'm just going to remove the Mr. Day, Mr. Woodcroft, Mr. Morass now into the waiting room. Thank you for attending today. Did you want to, Mr. Day?
I just wanted to say thank you to members of the committee and officers. Most obliged.
Thank you very much.
Thank you.
Members, if you could just wait one moment, we'll okay, and if you can wait one moment, we'll go back into the breakout room because we haven't got the members, the applicant for the second application as of yet. Just bear with me, thank you. Do you have a request at the bottom to join a breakout room, members?
No.
Okay, just bear with me. I think one of our officers have dropped out. Sorry, just bear with us.
Okay, Claudette, can you just confirm what you need me to do? You're on mute, Claudette.
Can you put the members and the licensing officer and legal into the breakout room, please? Just leave me here for one moment, please.
Okay, room is open.
Thank you, members. I'm just going to admit, we're broadcasting live. I'm just going to admit all the parties for the next application.
Claudette, sorry, I'm on the phone to Javier, who's running late at work and is able to join late. Is that possible?
If you could enter the waiting room, and then we'll see where we are in proceedings, because
Okay.
it's now 12 o'clock.
All right.
Thank you.
Okay.
Right, okay, can I just check everybody's, let's see who I have here. I've still got somebody still joining. Oh, right, lovely. Okay. Mr. Wilkes, can I ask you just to unmute yourself and just check your microphone for me, please?
Yeah, can you hear me now?
Yes, we can. I'm just going to put you back on mute until you're invited to speak by the chair. Thank you. Nicole, can you just confirm your name, just so we can check your microphone, please?
My name is Nicole Neo.
All right, lovely. Thank you. I'm just putting you back on mute. Thank you. Mr. Arnott, can you unmute yourself and just check your microphone?
Good morning. Can you hear me?
Yes, we can. Lovely. Thank you. I'll put you on mute until the chair invites you to speak. And I think I just got one more. Tom, are you there? I know that you just audio. All right, lovely. Thank you very much. Thank you all for waiting. Apologies, we were waiting for one more relevant person, but they're not able to join us at this moment. I believe the chair will be Councillor Tom Brooke. Am I correct? And I will turn over to you now to make the introductions to those parties present. And if I ask you to stay on mute until you're invited to speak by the chair. Thank you.
Thanks, and yeah, go on mute after you've spoken as well. Yeah, so welcome everyone. My name's Tom Brooke. I am Councillor for Bishopston and Ashley Down, and I'll be chairing this meeting. First of all, I'll ask the other. Sorry, press the wrong button. I'll ask the other councillors to introduce themselves. So, Lucy, do you want to go first?
Hi, my name's Lucy Whittle. I'm councillor for Wimble Hill.
Brenda?
Good afternoon. My name's Brenda Massey. I'm councillor for Southmead.
Thank you. So, just to outline the procedure that we'll be following today, so it's intended to be kind of informal, kind of non-adversarial kind of setup. So everyone will be invited to speak at the relevant time by the chair, by me, and kind of speak through me rather than to directly to individuals, to kind of keep that non-adversarial nature. So we'll start off with the licensing officer introducing the report, then the applicant or their representative will be invited to present the application. At that point, there'll be questions from the members and the officers. Following that, the police aren't attending, but the regulatory authority will have the opportunity to present their representation. And again, there'll be questions from members and officers, and the applicant can respond at that point if they wish. And then following that, the relevant persons, so that's the residents, and looks like Councillor Wright isn't with us, but if he was here, him as well, will be able to present their case. And then after that, there will be a summing up. So people will be invited to sum up, not introducing anything new at that point, just concluding what was said previously. Following that, the committee will go into a separate virtual room to discuss the result, and then we'll come back and tell you what we've decided. So hopefully that's clear. First of all, let's go to the licensing officer to present the report, please.
Thank you, Chair. So this is an application for the grant of a new premises licence in respect of Unit 2, Cannons Way, Millennium Promenade. The premise is due to be called Lane 7. Just for ease of reference, this is the premises that used to trade as the Cuban. The premises is described as a boutique bowling alley with food and entertainment facilities. The application originally sought the sale of alcohol on and off sales every day of the week from 10 in the morning to 2 the following morning, films indoors, indoor sporting events, live music indoors, recorded music indoors and outdoors were sought from Monday to Sunday, 10 to 2 in the morning. Late night refreshment until 2:30 every morning, and opening hours 2:30 every morning. There has been some change to that, which I'll cover in a moment. We did receive representations both from the police and from regulatory services. Agreement has been reached both with the police and regulatory services and the applicant, subject to a change in some of the hours and the attachments of conditions. The members have had the conditions sent to you yesterday and this morning, so you've got those in your paperwork. We also received 8 representations from relevant parties. In terms of the amended piece of representation which has been agreed, it states that the opening hours are restricted to midnight, Sunday to Thursdays, and to 1 in the morning, Fridays, Saturdays, and Sundays before a bank holiday Monday. Excuse me. And it also asks for or says they're happy to remove live music from the application. I did see clarification, and I may have inadvertently confused matters, so I apologise to the police and the applicant about this, just to check if that agreement also covered licensable activities, and it does. So the agreement is that licensable activities and opening hours are restricted to midnight and 1 o'clock respectively. Conditions were also agreed with the police, which is in the amended representation. Thank you.
Thank you. Do the members of the committee, the councillors, have any questions at this point? Nope. I see shakes of heads. Any officers at this point? No. Thank you. Okay, so now we'll go to the applicant. I believe, Richard, you're representing the applicant. Over to you to present the case.
Chair, members of the committee, good morning, and thank you for giving us this opportunity to present our application hot off the press. And Mark will confirm this. I think we've now just agreed conditions with him, but I'll go through those conditions in due course with you at the right moment. In addition, we had agreed with Councillor Mark Wright amendments, and that's really the basis of the amendments that you've heard from Carl there a moment ago. And he too was willing to withdraw his representation, and that may be why he's not with us today. So in terms of, I'll call them live objections, I think we're really now dealing with the residents and the residents alone. But again, I'll go through everything so that we don't, so that there's no misunderstanding of what we're asking you to consider. But all being well, and today is a very important part of all being well, Unit 2 will open as the 9th Lane 7 in February of next year, soon to be followed, we hope, by Edinburgh, Glasgow and Dublin. This project alone represents an investment of around £1.5 million and will create up to 40 jobs, part-time and full-time. As has already been indicated to you, Unit 2 was formerly a licensed premises known as Cuban, and we know from the research that we've done and things that we've seen that those premises were troublesome. They caused a great deal of concern to the neighbours. Can I say, first of all, that we have nothing to do with them, and equally as importantly, we are nothing like them. They were a bar with a dance floor, totally different type of operation. They are now long gone. Having said that, I think we appreciate that there is some residual concern that has in some way overshadowed our application, but hopefully I'll be able, through the course of my submission, to assuage all of those concerns, particularly for the residents. I've had dialogue with the responsible authorities, and I'll talk about that in a moment, but we haven't yet really had the opportunity to sit down with the residents. So hopefully at the end of this, no matter what your decision is, they will feel a little bit more comfortable with what we're proposing. Lane 7's policy, wherever we go somewhere new, is to engage with the responsible authorities before we submit the application. The theory being then that we address any issues early doors, and that when we do submit the application, we submit it with what is effectively an agreed schedule of conditions. We're also always willing to listen to sensible compromise during the consultation period, and that's something that is part of our culture when it comes to applying for licenses up and down the country. I contacted the police first on the 4th of June, and Sarah Bellamy quickly responded. And as a consequence of that, a meeting took place on the 8th of June at the premises with Tim, and Tim will have a word with you in a moment. Tim's the founder and owner of Lane 7, and that meeting was very constructive. It was attended by Mark, and he'll perhaps talk about that in a moment, but we also had 3 police officers there. The licensing authority was invited too, but they weren't able to attend. But as I say, that was a very positive and constructive experience, and Tim had the opportunity to explain what his business is all about, and we amended the proposed conditions as a consequence of that meeting to assuage some concerns that Mark had. We weren't told of any concerns at all that the police or the licensing authority had. So, with respect, we were slightly disappointed that we ended up with representations from them, but in any event, we were able in the end to deal with those concerns. Now, I don't have a fully paginated version of your agenda, but perhaps if you could refer yourselves to the original conditions, they're entitled Lane 7 conditions, and they're numbered 1 to 12. If you have them before you, I'll just briefly take you through them, bearing in mind, though, there have been additional conditions agreed through the course of the consultation process. You'll see the first condition, which is a very important condition. That's what we licensing lawyers call a concept condition. Now, one of the issues I know is that people are concerned about what might come after us. Well, with respect and in legal terms, and Ashley, I'm sure will agree with me, you must judge this application on its merits. Having said that, we cannot turn into something else. We can't become a Trojan horse. That was, I think, a fear that was evident from the conversations that I had with the police, although they were perfectly comfortable with us. What comes afterwards? Well, if somebody were to make an application to be something else, then you would know all about it because of that condition. So it sort of protects the concept, as it were. So what I'm about to describe to you is what we will always be. The conditions are very straightforward. Condition 4, though, has been changed because of the discussions with the police. So we've now adopted their preferred version, which they accept is really just a rewording of what we proposed in the first place. Incident log, staff training, that's very important, obviously. And then condition 7, the licensed trade is more and more tuning into the needs to safeguard. So that condition takes us in that direction, as does 8.
Sorry to interject there. It's just been brought to my attention that the residents won't be seeing the conditions. Would you mind just outlining what they entail as well as the numbering?
All right, sorry.
Thank you.
Well, the first condition, condition 1, is that the premises shall primarily operate as a bowling alley with ancillary facilities. That's the concept condition as I describe it. And that means that we can't become something else. The fear was, I think, that we would, having been granted our license, decide that, in fact, what we always wanted was to be a nightclub. And that can never be the case because of that condition. And condition 2 just supports that by saying that if we were to ever change the concept, we would need to make an application. 4 is CCTV, but we've agreed different CCTV conditions, but basically saying the same thing. 5 requires us to have a refusals and incident register, and those incidents, those entries must be monitored by the DPS, and that record is made available to the police or the licensing authority. Condition 6 requires us to conduct staff training. Again, staff records to be made available for disclosure upon request. Condition 7, no children under the age of 16 shall be permitted to remain on the premises after 7 o'clock unless accompanied by an appropriate adult. Condition 8, no children under the age of 16 should be permitted to remain on the premises after 8 o'clock. Premises license holder, this is condition 9, shall risk assess the need for the deployment of door staff and shall act accordingly. That condition, though, has been superseded by what we've agreed with the police. Condition 10, the external area marked in blue shall not be used by customers after 9:30 p.m. And the colours appear on the plan, which I'll go through again in a moment. And then the external area in yellow shall not be used by customers. Now, originally we'd agreed with Mark that that would be 11:30 p.m. But then that becomes, after discussion with the police, 11 p.m. And then the premises license holder shall operate a noise management plan in respect to the external area. Now, as I indicated, we've just agreed with Mark a condition relating to noise management, which I'll go through, if you don't mind, when I come to dealing with the representations themselves. But those are the conditions that we originally applied for, and they have obviously been subjected to discussion and amendment where it was felt appropriate. You should also hopefully have seen within the agenda what we describe as the brochure, and this is just a document that we've produced in an attempt to try and support the idea of the concept. Again, hopefully you've had the opportunity to go through that and you can see what we're all about. I don't know though whether the residents have had a copy of this. I think it's produced within the public agenda, so hopefully they have had the chance to see that. But in any event, from the outset, we've invited people to have a look at our website so they can see what we're all about. Just a brief bit of history. 2010-ish, Tim had a young family looking for things to do and realized that he was struggling, a bit limited. He came across, in the States, they have family entertainment centers, and they're also quite popular and well developed within Scandinavia as well. And that was the seed that was sown that eventually became Lane 7. He comes from a very entrepreneurial family. The family have had a petrol retailing business for about 50 years. It was started by his grandfather. He's property development as well. So he's, business through and through. And Lane 7 came about in 2012. The first site opened in Newcastle in 2013. And I did that application all those years ago. And some of the things that are being said by residents is what we remember from then in 2013. And I can assure them that there have been no difficulties whatsoever with Lane 7, either in Newcastle or elsewhere. We're very popular. Newcastle, as an example, for instance, we've had lots of very prestigious corporate events and corporate clients. So Apple and Barber, Wax Jackets fame, Northumbria Police uses for sort of staff events. My firm, we use Lane 7, but the NHS, other people as well, including the state of Nevada. They even hired Lane 7 in Newcastle. They were doing a UK roadshow, and they decided that they would like to use us as a base. Originally, in 2013, when sort of the concept was new, in terms of trying to find new sites, nobody was really interested in us. But as the idea has developed and as people know who we are and what we do, Tim now is bombarded by offers of new potential sites by property agents, and the business, the estate is expanding, as I've already described. If you could refer yourselves now, please, to the plan. Again, you should have this within your agenda.
What page is that? Have you got that, members? I don't know whether we should share that, Carl.
I believe it's page 79 in the on our pack.
It may be that the members don't, the residents don't have that. Carl,
It's on the end of the draft license, so
they may not have that because that's not shared.
Well, shall I try and describe it?
Please.
Yeah. Well, external area. I've given the external area two colours. One is blue and one is yellow. And those colours refer to the conditions that I've described. The blue area is the area which is closest to residents, and that's the area that will close earlier. In the discussion with Mark, and Mark will confirm this, I think, between him and Tim, they talked about landscaping and what can be done there to attenuate noise breakout. But the blue and the yellow designations within the external area were I think, Mark's suggestion. So again, happy to agree that. There is one main entrance. Customers come in and they then see before them the sort of reception area. And that's where everything happens. And when I say everything happens, Tim will describe in a moment what I mean by that. But you can see before you that these premises are set out for what we call in the trade competitive play. It's not a drinking venue. It's not about vertical drinking. You can see there what we have on offer to our customers. And in particular, you'll see the 5 bowling alleys. Now, just going back to that comment about Trojan Horse, if anybody wanted to come and do something else with these premises, they would have to remove those bowling alleys, and there would have to be a variation application. Everybody would know about that. But that would be absolute madness, because each of those bowling alleys, there we are, of those bowling alleys individually costs £70,000. So that's a substantial investment that's in bowling alleys alone that's gone into these premises. And Tim is telling me that even the slightest scuff or mark on the surface of those lanes requires attendance by the manufacturers, the people who maintain them, and that's £5,000 per visit. So that's a substantial amount of money. We have to obviously protect those lanes and everything else that we have within our premises. And that's another reason for saying that you can trust us, because we self-regulate. We can't be a troublesome premises. We have too much investment at stake. So you can see there what's on offer. There are arcade games. These are increasingly popular as well, sort of retro games, sort of Pac-Man and Space Invaders, things like that. In fact, there are premises now which specialize just in them, the old style games. And then you'll also see the food pod. There are 2 food pods there. The way that it works is that we will get local independent sort of startup type businesses. We like to support them, and they are that sort of food, that good food, locally sourced, is very popular as well. We're developing and soon to open, hopefully, a site in Leicester, which is a fantastic old Edwardian railway station. It's got massive space, including a courtyard, and we're going to do all sorts of things there, including a farmer's market. And that's kind of the direction that Tim wants to travel in. What I'll do now, so that I'm not taking up too much time, is I'll invite Tim to describe to you what the process is from the moment that you arrive and how you book your time with us, because it's quite a sophisticated process. And he will describe to you how people come to be in our premises and what it is that they're doing and how they do it. So if I can hand over to Tim at this stage, please.
Yes, good morning. So the business principle is that the main difference from a traditional bowling alley would be the service standards and the kind of overall experience we're trying to achieve. So in excess of 90% of all of our bookings across the entire estate is pre-book, and that's because of the resource level of lanes. If you have 10 lanes, that's only a maximum of sort of 50 people an hour. So on your busier days, you don't need a huge amount of people to fill that resource. So in every city, although we walk in trades, we really want that, people realise that to kind of secure the booking and the overall experience you want, you need to book early, a little bit like a nice hotel with minimal rooms. And internally, we kind of treat the customer service element when you come to site a little bit like a hotel. So you could make a basic booking online, but if you wanted to do multiple things, an hour of pool, ping pong, some bowling, reserve a table so you could eat at the food pods, you might, and you're a bigger group of 10 or 15, then we have some people at the head office who would bespoke that journey for you. You'd receive an email, and when you come to site, you would come over to the reception, and really that reception is very much like a hotel. So we would check you in, we'd get your QR code or your email receipt, and we'd say, great, you're here in good time. We like to open a tab. So very much like a hotel, you can just charge everything onto your bill. And then we'd locate you at a reserve table on our system. And in-house, we sort of call that the conveyor belt. So once we know you're booked in for 7 o'clock to bowl, you'll have got with us at 20 to 7, we get you a drink, you get your group in a certain area. And then at 7 o'clock, when your lane's ready, we'd bring you over, get your bowling shoes on, take you to the lane. And when that booking's finished on our booking sheet, we'll know what the rest of your journey for the evening would be. That might be that you have a little break and go and do some arcading or have some food and then do another booking at 9 o'clock, which could be shuffleboard, or it could be at 10 o'clock. Part of your group might do multiple things. Other parts of your group might dip in and out and just take a table in the venue so that you can sort of, everyone, you can come as a group, but bespoke as much as you like. The biggest thing about that is that where possible, we always run table service. It's not always possible, but it's better for us, and obviously it's better for the customer journey. If we run table service, there's multiple benefits. It allows for us to keep you at your activity that you've paid for, so you're not wasting time at the bar. It also allows us to offer a much better experience. And the principle would be that you'd have pre-booked your night. If you wanted to add something else on, if we had that gaming or resource available, you could, but if it was fully booked, we'd just inform you. When you come to the end of the evening, you would come back to the reception and we'd check you out just like you would check out of a hotel. For example, you can split your bill between your group, you can pay as you like. And that's how the bulk of our customers choose to have the Lane 7 experience. Like I say, in excess of 90% across the estate. Walk-ins is what supplements those little gaps. So you will always get walk-ins, which is sort of essential on off-peak nights, those quieter nights. If someone wants to walk in, they could come in and they would come to the reception and say, do you have anything available? So you might go, yeah, we've got a lane in an hour, but I've got a spare table if you want to take some food, or we've got a pool table coming up in 20 minutes if you want to take half an hour of that. So walk-in allows us to fill any gaps in that evening service. If there are no gaps, there are no gaps. Someone can take a drink at the bar, but like I say, because of the pre-book being in excess of 90%, we know that, and that's now across a number of sites across the country, we know that that's not a one-off in one city. We know that that's how everyone likes to enjoy the experience.
Can I just clarify, Tim? It's all for you about timings, isn't it? You push people through the system, because if you don't, then you're going to have a queue of people who've booked for a particular time and they're not going to be happy.
Yeah, so the timings, like I said earlier, we call it the conveyor belt. It's not particularly a glamorous way of referring to it, but we need people to sort of turn up on time, and the timings are essential. So that if you booked an experience that started at 7 o'clock and finished at 10 o'clock, so you're invoiced for 3 hours and you did 3 things back to back, we have to take you from, let's say, bowling from 7 till 8, pool from 8 till 9, and ping pong 9 till 10. That's totally reliant on all the other groups before and after on those resources, turning up on time and keeping us on schedule for the rest of the evening. Obviously, we build in a few firewalls, but it's essential to, if we turn the booking system off and just relied on walk-in trade alone, then it would be a car crash. You couldn't really run the site. How we make them successful is the fact that, like I say, much like a hotel, everyone books your stay, book what you want to do. Although we're not doing it over a day or a weekend, we're doing it over an evening, you're still booking that resource in advance. There's no other way of doing it for the bulk of the customers that you'd have through on those busier days.
And how does the end of the evening work?
So much like that conveyor belt principle. So when we open, obviously we don't have anyone in the venue. So let's say on a Saturday and you opened, we'd expect to have families in by midday. So you might have someone booked for 11 o'clock and another lane for 11:15, another one for 11:25. So all of a sudden, your resources are slightly offset. We don't set them all away at the same time. If we made people book on the hour, then your reception would be overrun every hour because you're trying to do it all at once. So we feather all of the resources. So what happens is someone might come into bowl at 11:15, then they go onto the pool at, let's say, 12:30. Someone else will come in on the bowling, and then someone else will come in on the pool afterwards. So over a number of hours, the resource would get full, all of your resources, your different gaming options. And as the day goes on, hopefully, if you're successful, you'd stay full. You might have a few drop-offs like late afternoon, between the switch between afternoon and early evening. What would then happen is, let's say it was maintained, you had a busy day, your resources all full. As the night comes towards an end, you will naturally, that conveyor belt needs to unwind. So you don't have a system where everyone just leaves at once, which truthfully is a problem for us at the minute with this 10 o'clock curfew, because we're having to jig the booking system because of that conveyor belt element. What would happen is you might peak at 10:30 And then people are still coming in, but they're coming in for shorter experiences, or your bookings may sort of cease at 11, there's no interest. So someone that came in at 10 to bowl till 11, they might have a game of pool 11 till 12, and some ping pong 12 till 1. So you're starting to see that conveyor belt and the booking system die off naturally. So we can always start 2 or 3 hour build up at all of the sites to get all the resource full if they're popular enough. That would maintain, let's say a busy Saturday in winter, that would maintain. And then towards the end of the day, you just see that natural reverse as that conveyor belt starts to let people drop off the end and leave the venue.
Yeah, we're bound to be asked, can people come in and just have a drink? Now, I know the answer is yes, but you don't particularly want those people because they cause a problem with the bookings, don't they, in terms of space? So just explain that.
Yeah, so what we in the industry, it's not just us, just in general, pubs or bigger groups, dwell time is the consideration. So how long does someone want to stay in a venue for? Because that's the ultimate number, and then you know how many times a restaurant could turn a table, depending on dwell time and service time. So for us, we have that same scenario. So you might have a group that are bowling from 12 till 1, let's say there's 20 of them, so they're coming on Saturday afternoon, and then 10 of them want to do pool and ping pong. We know that there's 10 people in that group, they're going to take a table in the venue to have a drink or take some food. So we're always having to leave some seating capacity in the venue for those groups that we have in, depending on how their day's currently being booked. A really good example of that is when the COVID measures have come in now, it hasn't actually meant a huge change to our business model. Because 90% plus pre-book, we already take lead names, numbers, guest names. We already allocate resources like tables, lanes, and we already have all of their journey mapped out before they come. So truthfully, until the 10 o'clock curfew came, which kind of throws us a little bit of a curveball, the other COVID measures haven't been a particular stress for us because we manage that journey and pre-booking of all of the asset in the venue. So if someone does walk up and we do have a resource available, we could give them a table for a drink or they could sit at the bar. But if we were full in the venue, that's very limited because what we can't do is sell you a really good experience and dwell time of 3 or 4 hours. And when you just have that hour in between to grab some food, which we've indicated, you don't have a table to sit at to take that time to have your food and grab a drink. So it's all built in to the way we run the business.
Thank you. Chair, I'll leave Tim there. Obviously, at the end of my submission, he'll be free to answer any questions that you or any of your colleagues have of him, but I'll just continue briefly and just comment on the representations, if that's okay. I won't take very long at all. Well, turning to those representations, it's always useful to briefly remind ourselves of the law. I always tread carefully at this point. I know you've got Ashley there to advise you on the law, but it's useful just to remind ourselves that we're within a process. The framework is set out by the Licensing Act. And there is no, as a matter of fact and law, cumulative impact policy for this area at the moment, but this is the moment in which we're making our application. So you will consider us on what I'll call the usual basis. And that usual basis is that the onus is entirely on objectives to convince you that there's evidence that we'll fail to promote the licensing objectives. Well established, 9.42 of the guidance, Honor Judge Black's comments and Thwaites as well. And residents always say, it's, you know, my weekly work is attending hearings like this. Well, that's not fair. How can you predict the future? We don't have a crystal ball. All those sorts of comments, but that's how the law is. And if you want to look at it in terms of balance, balance is restored by the robust enforcement prosecution procedure. We will not cause any problems. We're very confident of that. We wouldn't have bothered making this application and investing so much money in your city if we thought that we were going to be troublesome. We are nothing like Cuban. And we will, bearing in mind Cuban, will be judged on our merits, and that again is well established 10.10. So if I can turn to the representations, again, I'm slightly limited because I don't have a paginated full agenda. But if we can look first of all at the representation from Sarah Flower, which I think Mark is going to be presenting this, I think, yeah. I don't know whether Mark has had the opportunity yet to send his email to you that we've just agreed, but I'll go through the representation just to help him out. I'm sure he'll stick his hand up if I've said anything wrong. But so far as the representation is concerned, you've seen a number of conditions proposed. Condition 1, no speakers for amplification, music or speech to be placed in the outside area. Agreed. Condition 2, external doors and windows kept closed during periods of, well, we're not doing live music now, karaoke, DJs playing recorded music. Agreed. Condition 3, I had a problem with, the reason being that we were really at the mercy of a subjective decision by an environmental health officer. Now, I'm quite confident that your environmental health officers are all perfectly reasonable, but I have experience elsewhere, the environmental health officers who are otherwise. And the danger with the condition here is that we would be effectively held to ransom because it would be simply the decision of an EHO as to whether we were causing a disturbance. We might say we're not, we disagree, that if there were complaints that they were spurious. But then the second element of that condition is that there would be a noise limiter, and that limit would be set by EHO. Again, it would be entirely at their mercy. And I do have experience elsewhere of that process going wrong and a business having to close. So, but Mark's been very reasonable and well, he gets to his submission, he'll tell you what we've agreed, but he's no longer, I think, pursuing that particular condition for those reasons that I've explained. Then condition 4, again, I had a slight issue with that, but we've compromised that too. Condition 5, there was no need for that condition because all of our refuse is kept internally within the development, so there wouldn't be any noise escape. And condition 6, that is agreed. So subject to anything Mark has to say, I think he and I have shaken hands on that, and he's promoting that as a way forward for you too. The police, I've made my, well, the police and their representation talk firstly about the CIP. I've made my point in law where we are with that. I mean, I do accept that you're consulting at the moment, but as a matter of fact, there is no CIP, but so I don't think you should rely on that. But just as an aside, there is reference, probably about 3/4 of the way down that page, of the licensing authority welcoming proposals that can be viewed as more family friendly. That's us. So, you know, we hope the sort of premises that you want to promote, not just in this location, but throughout your city. Then the conditions, I won't go through the conditions. You've got them, the conditions as we've agreed with the police. Hopefully you'll be content with them. I don't think there's anything startling there. We've just added, or they suggested that we add quite a few conditions, which we're happy to agree to. Then Mark Wright's representation, again, we've compromised that, and he did send an email to the licensing authority telling them that he was withdrawing. So he is content. So I won't really comment. Safe to say that just if you are reading that representation, we were never intending having live bands. It's not that sort of venue. We just wanted some live music. If you had a corporate event, for instance, it might be that they would want, you know, a soloist or a duo. We would never want a band in there. It's just not, you know, it's not what we're about. And we would never want to disturb anybody at 2 in the morning. Having said that, all of our other premises, with the exception of Newcastle, trades to that time. So what we've agreed in Bristol is quite unusual for us. But again, if it helps everybody, if it builds some trust, then we will agree to that. Then going through the representations themselves, they're more or less the same. So I'll try not to repeat myself, but there's reference to Cuban. And that's why at the beginning of my submission, I mentioned Cuban. We are nothing like them. And hopefully we've managed to persuade you of that. We also don't want a nightclub. We don't want anything we never were a nightclub. And 2 a.m. is something that we've amended and we've pulled back from. And they are rather identical. There's mention of the areas. Well, again, I tread carefully here. Now, I don't live there, so perhaps not for me to say, but it's quite clear from what I've seen that this promenade, the ground floor was built for commercial use and licensed commercial use. So I accept that there are people living in the area, but equally the development was proposed, built in these sort of terms. I mean, for instance, you've got Slug and Lettuce, which is a few doors down, I think, and that has a license till 4 o'clock. So saying that it's entirely a residential area, perhaps that's not quite a correct representation of what's going on. But again, just emphasize that we're not going to upset anybody, and we will be a good neighbor, and hopefully everybody will enjoy using us, particularly families. Well, I'm not sure that there's anything that I can add. I'd say that there was one comment that Xavier Gutierrez made, saying that he feels unprotected by the council. Well, you know, we've amended the application. Conditions have a legal binding. If we breach conditions, then we can be prosecuted. We can have our license taken off us. That's, you know, £1.5 million wasted. It also reflects very badly on the estate. We can also be prosecuted. So there's ample protection there for residents. And at the end of the day, I think the residents deployed that against Cuban, and Cuban disappeared as a consequence. So, Chair, members of the committee, unless there's anything that I can usefully add, or if you have any questions of him, that's our submission.
Thank you very much for that extensive submission. Councillors, do you have any questions at this point? Brenda?
Just one for clarification, which is intriguing me. Looking at the brochure, could somebody explain what beer pong is? Does it involve alcohol, as it sounds like? It's on the front page of your brochure.
Councillor, it does, and I'll leave that to Tim.
Thank you.
Tim.
Yeah, so it's just another form of gaming. You buy some cups and you have, excuse me, just dropped something. You buy some cups and you have a very particular design table, and you use a ping pong ball to bounce the ball into the cups. It's just a game. You can choose how we sell the package is we just sell the cups and the table's free to use. So how people want to use it is up to them. It's no different to games like cornholing, which we do, which is free to use, which is we have little bean bags, hacky sacks that you throw from one unit into another to get through a hole. They're just effectively bar games that people can take on. Things like cornholing and beer pong are just, it's either free or it's a couple of quid for the cups in that case. They're what we would call fillers. So if someone's got an hour or 2 hours between different things, they're things that people can do free of charge or virtually free of charge.
Okay, thank you.
Any further questions from the councillors? No. Any from the officers at this point? Nope. Thank you. Okay, so at this time we will move to Mark. For you to say your bit.
Okay, can you all hear me okay?
Yep.
Yeah, I'll just reiterate that I agree with everything that Richard and Tim has said. I did meet Tim at the premises some time ago now, and at that stage my concerns mainly were with the outside area, and we agreed the sort of not cordoning off, separating that into two areas, and one area closing earlier than the other, the area being nearer to the residential properties. I think, as far as I'm concerned with the premises, I think, as Richard says, it is intended for commercial use. That is the planning consent there for the premises. And I'm of the opinion that if properly used, if properly managed and in compliance with the license conditions, that shouldn't cause any disturbance to local residents. As far as the conditions which Richard has gone through, I think there was two conditions there which I'd asked for, which there was some or need to look at those with the applicant. Those were the first one which Richard mentions, which was with the provision of a noise limiter if we, as the council, witness that as a nuisance. Fully understand the concerns there, and that's something which I've come across before. The other condition which I'd asked for was one for the operator to monitor the noise on a regular basis to ensure there's no breakout to the premises. And I think the applicant's concern there was that they wouldn't be causing any nuisance. And if this is carried on after they've proved that they've not caused any nuisance, they will just have to keep monitoring for monitoring's sake rather than it serving any purpose at all. So Richard and I myself have agreed that rather than those two conditions, we would replace those conditions with a noise management plan condition, where the applicant has to set out how they will monitor the noise from the premises and what actions they will take if a noise nuisance is established in the future. So that will then offers us the same sort of protection as what we have from those two previous conditions, but also gives greater flexibility for the applicant and takes away that need for them to just monitor something for the sake of it when we all know that it wasn't causing a problem. And that's the end of my piece.
Okay, thank you very much. Councillors, any questions to Mark? No. And supporting officers, anything? No. Thank you. And also the applicant at this point has the opportunity, if I think you've covered everything. Yeah, thank you. Okay, so we now move on to the relevant persons, which is the residents. So just to clarify, who's are both Nicole and Tom wanting to speak, or is one speaking for everyone?
I think, Chair, they both want to speak.
Yep,
Yeah,
that's fine.
Speak,
yeah.
I'm happy to speak, yeah.
Okay, well, Tom, given you're already unmuted, we'll let you go first.
Oh, sorry. Yeah, so my only concern is the noise pollution that could come out of the place. Beer pong and, you know, cocktails and things like that, and music. Beer pong being a drinking game which people get quite drunk off, if I remember when I played it. So my concern is if the outside seating area, I think it was 11 p.m. you said it was shut. There's quite a lot of seating, public seating outside the bar that's, you know, free for anyone to sit. So one of my questions was, if someone left the premises, could they go and sit there and then come back in? Is it kind of a free flowing? I imagine it is. So I'm kind of concerned about how the noise is going to be controlled at 1 o'clock, midnight on a Tuesday or something like that. What's going to be the protection against this kind of noise pollution?
Tim, can you address that?
Well, I was just going to say we'll let both residents speak, and then everyone can respond to questions at that point. Do you have anything else to say, though, Tom?
Yeah, I mean, I don't know whether this has already been covered. There was quite a lot of information absorbed, but is the actual premises itself, will it have sufficient, noise protection? It's a bowling alley, so it's going to be plenty of noise with people inside. So I just don't know what the actual noise dampening is and whether that'll be sufficient. So if I was, for example, outside my building, would I hear anything? Or if I was, just sat watching TV, would I be able to hear anything? It's kind of the concern I have. Actually, more importantly, if I'm trying to sleep, would I be able to hear anything? But yeah, that's one of my concerns, more or less.
Okay, thank you. Nicole, do you want to have your say at this point as well?
Yeah, so my concerns are about the noise insulation, as Tom mentioned. So Cuban, before they closed, they had a meeting with the residents because they were going to install the insulation materials, and they wanted to consult with us and reassure us, but obviously that didn't happen because they shut down. And another one is the hostility of the lawyers from representing Cuban. So in the hearing for the Cuban that was held last year, they threatened one of our residents because she was making complaints, and it really terrified her. Yeah, that's it.
Okay, thank you. I'll give the applicant the opportunity to come back on things first, and then see if officers have anything else to add. Don't know which of you wants to go.
Yeah, Chair, I'm 53, 5'7", and I'm 10 stone wet through. The thought that I could intimidate anybody, I would hope that I would never ever do that, and it doesn't work either. So there's no point in trying to intimidate anybody. So can I assure Nicole that that's not the sort of thing that I get up to. So far as noise generally from the premises, we just have to be careful here. That's not really a licensing matter. Bowling isn't of itself a licensed activity. That's dealt with under Environment Protection Act and planning, but I'll just defer to Tim and he can tell you about that, but also the issue that Tom raised about people leaving our premises and then being sat within the public realm, which again, from a legal perspective, we don't have any control over, and the Act doesn't require us to be responsible for those individuals in the sense that once they're out of our control, that's where the guidance says our responsibility ends. But I'll leave that to Tim to address you on.
Yeah, so I'll start with the noise came up a couple of times. So noise in terms of in the venue is we designed the venues, which were got a number of them now, all in city centres. Obviously, each building and location is different, but it's something that comes up each time. So within our agreement with the landlords had to carry out we're carrying out the work, some acoustic work at the landlord's cost. They're picking up the bill, and that's already all been carried out by the landlord's acoustician. So there is some extra work that will be getting carried out to the building. That'll be the first thing that happens before any of the standard fit out takes place. There are some things that we always take into account. So we always put the pin setters. That's the end where the pins go over. If you look at the plan, they're down in the very, very back of the building. That's been very deliberately designed on this site because about halfway down our site, that goes from, there's a tenant above us on the front half. As you go deeper into the building, that becomes the car park. So there's no real sensitive issue on that back end. So although some of the bowlers are up near the glazing at the front, the actual pin setters where the bulk of the bowling noise that's generated, that's down at the far end of the building. So then I suppose it's a question of general noise from customers at the front end of the unit. It's no different to a number of other sites we've got in different cities. We've never had a particular unit that's struggled with what's classed as, I'm not an acoustician specialist, but that's classed as breakout noise. So breakout noise is what's coming through the glazing, potentially drifting through that front door. We are in a building called The Cube in Birmingham. We're above a swimming pool and spa, and we have restaurants all around us. And we've never had and when I mean all around us, within 6 meters door to door. And we've never had, and a conferencing and event space where there's sometimes business meetings happening. And we've never had a complaint from that breakout factor. So the bulk of the noise would actually be the bowling. That's at the far end. The breakout noise, we've never had an issue with the same glazing sort of detailing to the front of the building. The kind of issue of noise that's more from guests. So it's never in anyone's best interest for our business model. We're trying to sell a long dwell time, a long experience, and try and give you really good, a full night out, 3, even up to 4 hours. It's not in our best interests if customers would feel slightly intimidated to approach that front door. You'd be penny rich and pound poor. So as Richard pointed out, once that guest leaves our premises and finish their journey, we can't force them to go anywhere, their own free will. It is in our interest to try and make sure that all guests leave quietly, don't reside in our front door area, because we might have other guests that are coming in for a new experience. And I think that as much as, I can't promise on that, you just have to understand that, like I say, to have large groups of people who maybe left, or groups of a 10 and an 8 dwelling around our front door area, is just not good for our reputation or our business. We have a very mixed client base. We have a clean 50-50 split of male and females. And if we're wanting to take that female and those groups of girls and ladies or mixed groups, they don't want to see that when they approach the door. So like I say, to get this right, like all our other venues, that sort of environment around that front door area is something that we just couldn't accept from a business model point of view.
Okay, thank you. Mark, do you want to say anything in relation to the issues the residents raised?
Yeah, all I would say was with regard to the premises itself and the sound installation of the building. I was involved when there was the noise issues with the Cuban, which had live music. This premises isn't proposing to have live music. The main problem there, I think, well, there was twofold. They on occasions had live music outside in the street, which no doubt caused problems. And also they were keeping the front door open when they were having live music on. So immediately you open any door, doesn't matter how good your sound installation is of the premises. If you open the door, you open a window, everything comes out of there. So as far as the building has got a glazed front, so that, I mean, it's not the best sound insulation properties, but that's because of the distance they are from the residents there, the type of glazing. I'm perfectly content that that is sufficient there for that type of premises to not cause nuisance to the residents nearby with when the doors are shut and the entertainment's played at a reasonable volume.
Okay, thank you. So we're at the point in the meeting where we're asking people to sum up. So first we'll go to the relevant persons, which means the residents. Then to Mark, and then to the applicant. Just a reminder that in summing up, please don't introduce anything new. It's about a recap, and to the residents, don't feel like you have to go over things again. This is just to keep it as concise or lengthy as you like. It's completely up to you. Nicole, I'll come to you first, given we did Tom last time, so go ahead.
So based on what you say, that the problems that we experienced with Cuban will not repeat with lane 7, I'll be happy with the condition that the residents have designated contact, which we can call or text to report if the noise gets too much, so that the relevant parties can be moved on or told to tone down. That's all.
Okay, thank you. Tom?
Yeah, so I'm happy with what's just been said there about the noise in the premises. I'm content that won't cause an issue. I'm still concerned about the sort of after effect. You know, if we're talking, you know, on Monday night, this place is open till midnight. You know, I think it was Richard that said that he's, you know,
Tom, I think your sound's gone somehow. I'm not sure if we lost you.
Am I back now?
Yeah, you're back now.
Sorry, right, okay. So yeah, I think, you know, it's one thing saying that the premises isn't going to cause any noise pollution and that it's all been taken care of, and then at the same time saying, oh well, if someone leaves this area, they're no longer our responsibility, which I get and I appreciate from a legal perspective, but it doesn't really change it from my perspective. So I'm happy with the noise inside the premises, but I'm still concerned about the after effect. If, say, you've got people who are drunk leaving at 12, you know, midnight on a Monday. Once they leave the area, that's it, and there's going to be noise for the next few hours. Whereas if it closed a bit earlier at 11, at least there'd be some kind of, or even earlier on a Monday, Tuesday, at least it'd be sort of everything's brought forward. So that's my concern.
Okay, is that everything you'd like to?
Yes, yeah.
Thank you. Okay, so now Mark, to sum up, please.
Nothing really to sum up. I think everything, my concerns would be covered by proper management of the premises and compliance with the conditions. Thank you.
Okay, thank you. And the applicant, I don't know which of you wants to do the summing up. But...
Yeah, very briefly. I just hope that you've got a sense from all of the compromise, from all of the engagement, the discussions, the meetings of how Tim operates his business. He has absolutely no interest in upsetting anybody. There's nothing to be gained from that. We've made what we think is a good, sensible application. We've listened and we've compromised. The times that we've sought to be blunt, we need, because then there has to be a sustainable business here after all. But we won't upset anybody. We won't cause any problems. So I commend the application to you, and we'll continue talking to people. If the residents want to talk to us, that's fine. Hopefully they'll become sort of invested in the premises as well, and in due course they'll see that we're an asset.
Thank you. So now's the time where we're going to adjourn for the deliberation from the councillors. I'll hand over to Claudette from Democratic Services to talk through the technicalities of that.
Thank you, Chair. My colleague will now move the members and the legal advisor and policy officer to the breakout room, and everyone else, if you could go into the waiting room, and then we will send you messages as to when we will be making the decision. And actually, Chair, I noticed that it's 1 o'clock. And I was just thinking if we could have the decision and a break and decide on a time now, so that everyone will come back and we'll put up the appropriate notice.
Should we say past?
past, right?
Does that
yeah, that
sound okay to everyone?
So if everyone could ensure that they're on their monitor at 1:30, that'd be absolutely great. Thank you very much, Chair. Can I ask Mara to move everyone to the waiting room and those to the breakout room, please? Thank you. Chair, I'm just going to admit all the parties to
Cheers.
the room. Just one more person to join. I think his internet is.
Who was it, aren't there? There's
Richard
and Mark.
The agent. I think his internet may be stalling.
Chair, Mark Curtis isn't joining for the decision.
Oh, is he not? Okay.
There he is.
Right.
Yes, lovely. Thank you, Chair. Over to you. Thank you.
Thank you. So thanks for waiting, bearing with us, everyone. So the members have carefully considered the representations made by the applicant, the regulatory authorities and the relevant persons, meaning the residents. Whilst it was accepted that the agreed conditions would alleviate much of the concerns raised, the members felt that the condition 5 relating to external refuse should be inserted just in case refuse was kept outside for whatever reason in the future. And there should also be a condition relating to the provision of a contact number for residents to complain in the event of a noise nuisance on an evening. So the application is therefore granted in part and refused in part.
Thank you, Chair. Thank you, applicant and members. We will now conclude the meeting. Thank you for joining us today.
Sorry, could I just clarify? You say granted, it's granted entirely subject to additional conditions.
Ashley, do you want to advise the wording on that came from you?
Yes, sorry, it's the wording we generally use. So the application as it came in obviously hasn't been granted in its entirety, but obviously when you have a situation where conditions are agreed with the parties, because it isn't as it was initially applied for, it's technically granted in part and refused in part.
But yeah, in plainer English, maybe granted subject to those extra conditions.
Wonderful. Thank you very much.
Thank you, everyone.
Thank you.